Yes, Mr.
My lord, in this appeal, my lord, the board is before the appeal court, my lord, challenging an order passed in a writ petition, which was filed by 140 writ petitioners, my lord, challenging, my lord, a recruitment process, my lord, which was initiated in the year 2016 by the West Bengal Board of Primary Education.
Yes.
My lord, I would like to, my lord, take your lordships first through the writ petition before, my lord, placing the judgment under appeal, because we have got a lot to say about the confines of the writ petition and, my lord, how it has been expanded, my lord, contrary to, my lord, all the procedures that, my lord, are available, my lord, in the judicial system.
Yes.
But if your lordships may kindly take the writ petition, which starts at page 36. But I am starting from internal page 28 of the writ petition after the cause title.
Appellant is board and its chairman.
ठीक है, अच्छे थे,
Its functionaries are there. পর্যন্ত। তুমি move at middle box. Equivalent.
board president and secretary.
All right. Yes.
But unsuccessful candidates are before the High Court in the writ jurisdiction. Please take, my lord, page paragraph number 3 onwards. Your petitioner states that on 19/10/2012, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary schools. It is needless to say that there were huge irregularities in TET 2012 and several cases were filed. In spite of irregularity and illegality, 18,000 teachers were recruited, and Government of West Bengal gave one exemption to the aspirants of TET 2012, that the aspirants of TET 2012 can sit for the next examination, and in that case they shall be exempted from paying any fees for the examination. The petitioner states that on 12/11/2014, NCTE published a notification dated number so and so, and in that notification, qualification and other procedures for recruitment were prescribed. Para 5, your petitioner states that on 9/4/2015, Ministry of Human Resource Development published a notification under so and so dated 9th of April 2015, extending some relaxation to the state of West Bengal till 31st of March 2016. Your petitioner states that on 14/7/2015, Government of West Bengal published a notification framing certain rules disclosing about the requisite qualification, etc. Then 7 is, your petitioner states that on 11/10/2015, TET 14 examination held in West Bengal, where huge number of students appeared. It is needless to say that on the date of examination, the notification issued by the MHRD was in force, and all the students who passed and or qualified in TET 14 should get benefit of the notification of 9/4/2015. Your petitioner states that on 2/3/2016, the recruitment rules of 2016 was notified, and Rule 6 of the notification speaks about qualification of persons who are seeking and or eligible for appointment. In clause 6, subclause 3, some specific guidelines are there for non-trained teachers. It is needless to say that all TET 2014 candidates are entitled to get benefit of this instant rules and the notification issued by MHRD. Your petitioner states that on 14/9/2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26/9/2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. Or in other words, Millard, first the trained candidates will be appointed, and for the rest of the vacancies, untrained candidates. That was the relaxation. It is needless to mention that MHRD gave relaxation only till March 2016, and in spite of the of that, the board notified that the candidates who do not have the training will be considered too. The notification proves that the board decided to give uh, something of the relaxation benefits of relaxation to all TET 2014 qualified candidates. Your petitioner states that after the notification, the procedure was started for appointment from October to December 2016. The interview and verification started on 31st of January 2017. Allegedly, the merit was declared, but there was no panel, there was no merit list, there was no category wise, merit wise, no division of numbers, and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether she was impaneled or not. No merit list was ever published, and in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 31/2017, list of trained candidates were published. On 4/2/2017, list of non-trained candidates other than the Bengali medium was published. And on 8/2/2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates of TET 14 were appointed through the first list, and after completion of the same, as per notification of 2nd March 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. Your petitioner state that on so-and-so date, notices were published for recruitment as assistant teachers in primary schools from TET 2014. The board has appointed non-trained teachers after 2016 even, and intentionally ignored the petitioners by giving excuse of notification of MHRD by way of so-and-so dated 9th of April 2015. Thousands of non-trained students were appointed, and petitioners, those similarly placed, were ignored. But this is the only case. Petitioners who were similarly placed were ignored.
They were also non-trained.
Untrained candidates or non-trained candidates. Untrained. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by the NCTE is applicable to all in any TET 2014 candidates who qualified in the examination.
So they board appointed untrained candidates. Petitioner says that I am also an untrained candidate, but you have not included
me, or you have given deprived me and given appointments to other non-trained candidates. But this is the short case. Now this has been stretched to I should say, my lord, and illogically extended, my lord, adjudication of the matter. Your petitioners state that recently the TET 14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23rd December 2020, the West Bengal Board of Primary Education published one notification of recruitment of 16,500 primary teachers. This is the subsequent recruitment process. I don't think I need to trouble your lordship with this part. Then 13, Millard, they give examples of 4 persons who were allegedly non-impaneled, but they got appointment. And then, Millard, kindly take, Millard, paragraph 14. Your petitioner states that at present, there is more than 1 lakh vacancy in the education department. Since 2011, several examinations were conducted to fill up the vacancies in the school, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected. These are all prejudicial facts. Then, Millard, paragraph 15 is, Millard, one honorable member of the parliament had made certain comments. The others are MLAs who have made certain comments. Then paragraph 16, biggest scam, TET 14 is the biggest scam. Para 17 again, TET 14 is the biggest scam, and 14 to 20 lakh rupees were exchanged. Then kindly take, Millard, para 18.
So you were unsuccessful in TET?
The writ petitioners. No, they were successful in TET, But as your lordships know, my lord, TET is a qualification for applying as for recruitment for the
So they passed TET.
yes, so far as passing of the TET examination is concerned, there is no dispute.
Now they are saying that TET
That
is,
they have been, yes, what their case is that they also fall within the untrained or non-trained category.
who were not successful in TET.
No, everybody are successful because unless somebody is a TET qualified, like me, I can apply for enrollment only if I pass the LLB degree course, or I can apply for judicial service provided I pass the LLB course. So therefore, TET is like a qualification,
Eligibility for
is one of the eligibility criteria. Your petitioner states that the board has started different cases before this court, that 42,897 candidates were selected till date, but no merit list of the candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, and a reservation category wise list should be published. Candidates were informed through SMS, and no merit list of so and so candidates were published, and it proves the mischief in the recruitment process. If the process was free from all corruption, then there ought to have been a transparent merit list of so and so. The process was not completed in February 2017, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers, but these are all submissions without any proof whatsoever, any evidence whatsoever. Be that as it may, I will deal with each of the allegations. Were appointed as primary teachers by the board, and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have given suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 14 qualified candidates were not issued to them, and even today they were fighting for that. There is no delay in filing the PIL, etc. I do not know from where, Miller, they have copied this, but this is there. Then, Miller, para 19. The petitioners state that your petitioners are hailing from poor families, and if they were recruited in time by giving them opportunity of being trained, etc. I don't think that these are that important. Then para 21, 22, they all speak of corruption everywhere, and then are the grounds. Now, what is very, very important is the prayer and the date of affirmation of the written.
So you tell us what was their pleading based, what were the arguments they were advancing?
Millard, I can speak of the argument provided, Millard, the proceeding was confined to or limited to the pleadings